Welcome everybody, good evening, good morning, good afternoon, wherever you are based in the world. My name is Dr. Emily Jones and I am a lecturer in the School of Law at the University of Essex. And I am the co-convener alongside my colleague Dr. Megan Wong, who you can see on your screen, of the Essex Public International Law Lecture Series. It is my absolute pleasure to be your host for this event, and we're very pleased to have with us today Professor Attila Tanzi of the University of Bologna, as you can also see on your screen. Professor Tanzi will be speaking on the topic of a common but differentiated law of international adjudication. And the lecture is to then be followed by a short response by Dr. Nilofer Oral of the University of Singapore, who you can also see on your screen. So Dr. Oral is a member of the UN International Law Commission, where the 72nd session is currently ongoing in Geneva, which is where she's joining us from. So Dr. Wong and I would like to take this opportunity to thank her for joining us today, despite her very busy schedule, and also to thank her for the very important work that she is doing. So it's a pleasure to have you both with us today. I will shortly hand over to Dr. Wong to introduce our speakers properly, but before I do so, I just wanted to say a few words about the series more broadly. So a few of you have probably joined us before, so you know about our series, but just to remind you, the Essex Public International Law Lecture Series is co-founded and co-convened by myself and Dr. Megan Wong. And we're both international lawyers, but Dr. Wong is a formalist and I am a critical international legal scholar. So the series is really built upon our differences and the deep respect we have for one another's scholarship, despite these differences, as well as, very importantly, our friendship. The series prides itself, therefore, on building on these two important intellectual traditions, formalism and international legal practice, and critical international legal theory. So we had a great lineup last term. I won't remind you of all of those speakers. Most of the videos you can find on the Essex Law School YouTube page. But this term we had Professor Karen Knopp of the University of Toronto speaking in our lecture series last week. And coming up, we have a number of exciting speakers as well. So on Monday, we will have Professor Naz Modizadeh of Harvard Law School. We also have coming up Judge Ida Caracciolo of ITLOS. We have Professor Diane Otto of Melbourne Law School, Osvaldo Arisha of the Universidad Católica de Valparaíso, Professor Clyda Hernandez of KU Leuven, Judge Eric Venestrom of the European Court of Human Rights, and Professor Anne Orford of Melbourne Law School. And then our final event of the term is a very special one with a particularly special lineup. So we have Judge Maria Teresa Infante Caffi of ITLOS. We have Professor Malgosia Fitzmaurice of Queen Mary University of London, Professor Fontini Pazarsis of the National Capodistrian University of Athens and the chair of the UN Human Rights Committee, and Professor Patricia Galvo Telos of the National University of Singapore and the Autonomous University of Lisbon, and another member of the International Law Commission. So pretty good lineup that we have for you this term. Do join us for those events as well. But really, today is of course about today. You're tuning in specifically for this lecture. And I will now take this opportunity to introduce you to your chair for this event, which is Dr. Megan Wong. Dr. Wong is a lecturer in the School of Law at the University of Essex and the director in the LLM in International Law. She is a generalist public international lawyer and has advised states on a broad set of issues in international law. She holds a PhD in public international law from Leiden University, and she is also the author of a forthcoming monograph, which is coming out with Cambridge University Press, entitled Responsibility of States and Individuals, Aggression at the International Criminal Court. So without further ado, Dr. Wong, over to you.
Thank you, Dr. Jones, for the kind introduction. It is truly a pleasure and joy for me to chair this excellent event today with our two esteemed speakers, Professor Attila Tanzi and Dr. Nilofer Oral. It is my honor to introduce them to you today. A few housekeeping rules before I start. Professor Tanzi will deliver his lecture, which will be followed by a comment by Dr. Nilofer Oral, who's our discussant or commentator. Then there will be a time for a Q&A, and you can address questions to Professor Tanzi or Dr. Oral or more generally, and they can decide who addresses your query, please feel free to list your name and affiliation, which I will read out unless you select to be anonymous. And now let me introduce our esteemed speakers. Professor Attila Tanzi holds the chair of international law at the University of Bologna, the oldest university in the world and undoubtedly one of the most beautiful universities. He's an associate member of 3 VB chambers. And as we all know, the peaceful settlement of international disputes is one of the underlying tenets of peace and security in our international legal order, corollary to the prohibition of the use of force. Professor Attila Tanzi has played a significant and varied role in the peaceful settlement of international disputes. He is instructed by governments, international organizations, and corporations on various matters of international law. He has been counsel, advocate, arbitrator in interstate and investor-state disputes, and he holds the appointments of member of the Permanent Court of Arbitration for Italy's national group, conciliator at the OSCE Court of Conciliation and Arbitration, and is the elected chairperson of the Implementation Committee of the UNECE 1992 Convention on the Protection and Use of Transboundary Watercourses and International Lakes, the Water Convention. He is also the former chairperson of the Compliance Committee of the 1999 UNECE Protocol on Water and Health. Although the focus of Professor Tanzi's lecture today is on international adjudication, the legally binding methods of dispute settlement, I also want to take the opportunity to highlight the role he has played in other forms of dispute settlement and the contributions he's also made to the international community. He has been a part of the Italian delegation in numerous multilateral settings, including at the UN General Assembly's 6th Committee. In his former capacity as the chair of the legal board of the UNECE, he triggered the amendment process of the Water Convention in order to allow accession by non-UNECE member states. The UNECE Water Convention from a regional convention is now a global convention, making it one of only 2 global treaties on fresh water. And in his role in the implementation committee of this now global treaty, he recently chaired the very recently concluded successful first advisory procedure regarding Albania and Montenegro. Professor Attila Tanzi's practice started in the LC case at the International Court of Justice between USA and Italy. He has been lead counsel and advocate for Italy in several cases, Italy and Costa Rica, the Enrique Lexi case with Italy and India, the North Star, Panama and Italy. He has been appointed as an arbitrator in numerous cases, both in investor-state arbitration for the investor, as well as states and interstate arbitration, including in the only modern diplomatic protection case of Italy and Cuba. I have had the pleasure of following Professor Tanzi's scholarship, of which he has published widely on generalist issues of public international law, and his fields of expertise include investment law, the law of the sea, jurisdictional immunities, and the law of international organizations. He is a leading light in international water law, international environmental law, international dispute settlement, and international procedural law, of which he has been invited to deliver a lecture at the Hague Academy of International Law on the principle of jura, novit, curia in international judicial and arbitral proceedings this summer. Professor Tanzi is the author of a number of books, including Introduzione al diritto internazionale contemporaneo with Chedam, International Investment Law and Arbitration, an introductory casebook with Chedam as well, and a concise introduction to international law with 11 International Publishing. He has an extensive publication record of peer-reviewed articles and chapters, including publications in the Italian Yearbook of International Law, European Journal of International Law, Leiden Journal of International Law, and the International Community Law Review. And my personal favorite is Professor Tanzi's article, "Is Damage a Distinct Condition for the Existence of an Internationally Wrongful Act?" in Marina Spinetti and Bruno Simas edited United Nations of Codification of State Responsibility, published in 1987. Professor Tanzi, we look forward to hearing your lecture today, and it's now my pleasure to introduce Dr. Nilofer Oral, our discussant commentator today. Dr. Nilofer Oral is the director of the Center for International Law at the University of Singapore, a leading center for international law in Southeast Asia engaged in research and capacity building in various topics of international law. She is also a member of the law faculty at Istanbul Bilgi University, Turkey. She is a member of the International Law Commission, where she's a co-chair of the study group on sea level rise. And if I could echo Dr. Jones to appreciate my gratitude to Dr. Oro for her generosity in taking the time during the ongoing ILC sessions to be a commentator for our event today. So thank you, Dr. Oro, for being here with us today. It's really a pleasure to have you. In addition to the International Law Commission, Dr. Oral also plays an important role in other multilateral settings, for example, when she served as climate change negotiator for the Turkish ministry. Dr. Nilofer Oral, in addition to being an excellent international lawyer and member of the International Law Commission, is also a leading authority on the law of the sea. She's a member of the International Union of Conservation of Nature World Commission on Environmental Law Steering Committee and was elected to the IUCN Council in 2012 to 2016, where she served as the co-chair of the WCEL Specialist Group on Oceans, Coasts, and Coastal Reefs. Dr. Oral is also the series editor for the International Straits of the World publications with Brill, a member of the board of editors of the European Society of International Law series, a board of editors for the International Journal of Marine and Coastal Law, the associate editor of Research Perspectives in the Law of the Sea with Brill, the board of advisors for the International Law Studies Journal and International Advisory Board, and Chinese Journal of International Law. She has published numerous articles, edited several books, but I wanted to draw to light her recent publications, which touch directly on international adjudication, which is what we're here to listen to today. If I could point out her recent publications, Ukraine and the Russian Federation, Navigating Conflict over Sovereignty under UNCLOS in International Law Studies, and co-authored with Massimo Lando, Jurisdictional Challenges and Institutional Novelties, Procedural Developments in Law of the Sea Dispute Settlement 2020 and the Law and Practice of International Courts and Tribunals. Dr. Nilofer Oral has appeared before the International Tribunal on the Law of the Sea and the request for an advisory opinion submitted by Sub-Regional Fisheries Commission. So Dr. Oral, we are looking forward to hearing your comment of Professor Tanzi's lecture today. Professor Tanzi, if you would like to commence your lecture.
Well, thank you very, very much, Dr. Wong, for your over-generous words and all that deep research work you did. And very many thanks to Dr. Emily Jones and yourself for the kind invitation to lecture in your series, which I understand has become a classic since virtually its inception. And I also wish to warmly thank Dr. Nilofer Oral for so kindly accepting to act as a commentator today, despite her overloaded diary, not to mention her pressing ILC commitment, including this very day, I understand. I'm sure you will add flesh and blood to the rather abstract skeleton that I am going to illustrate in my speech. The distinction in your series about international lawyers made me think of a joke by Philip Allott at an easy lecture he gave at the Lauterbach Center a few years ago. He jokingly said there was only one distinction among international lawyers, namely between thoughtful international lawyers and the rest. Let's say that you can put me in the league of those who strive to become thoughtful whenever they address an issue of international law, in a say of sort of a never-ending circular Dante's game. Other than that, I suppose you can place me among those who confine themselves to discussing the law in the way they believe it would be pleaded before the bench or applied by the bench. I may discuss how it has been applied in the past, and in the bravest of moods, how I believe lawmakers might adjust the law to social needs as I see them, no more than that. Now to my lecture. I will organize my presentation in 4 parts. First, I will make my proposition in broad brush terms about commonalities and differences in international adjudication. Second, I will qualify such proposition by introducing the taxonomy I will be following. Third, I will test the main tenets of what I regard as the law of international adjudication against the case law pertaining to each of the 3 different international adjudicative contexts that I will address. I will conclude by trying to extract the rationale of the differences that emerge between different judicial contexts while singling out one unifying procedural common thread, as I see it at least. The rules governing the functioning of international courts and tribunals have been increasingly portrayed as belonging to some kind of a common law of international adjudication. I may recall Professor Chester Brown as the front runner in this approach, which is perfectly consistent with the fact that, as appropriately stressed by Professor Shani, international adjudication has developed through a process of replication and adaptation. Therefore, I certainly can but fully concur with this approach with regard to the procedural rules which govern the conduct of proceedings. I mean, I agree that such rules apply homogeneously throughout the whole spectrum of the various forms of international adjudication. Take the equality of arms principle with its corollaries. It applies to the civil law kind of interstate litigation very much on the same footing as to the procedural treatment of the public prosecutor and defendant in criminal proceedings. Different considerations, however, I believe apply to those rules or principles which govern the adjudicative deliberation-making process. It is in that sense that I distinguish between procedural law and the law of adjudication. As I see it, there is inevitably a degree of overlap between the two, with a margin of commonality throughout the various forms of international adjudication. A significant example is given by the inherent powers doctrine, to which I will return shortly. I suppose these few introductory remarks call for a quick statement of taxonomy. First, I will briefly illustrate the just anticipated distinction between procedural law and the law of adjudication proper. Second, I will indicate the 3 litigation contexts where I see a differentiated application of the general tenets of the law of international adjudication. Now, I regard procedural law stricto sensu as the body of rules which govern the adjudicator's powers concerning the institution and conduct of proceedings. I am referring to the rules which address the terms, modalities, and admissibility of the submission of the application, or the notice of arbitration, as the case may be, written and oral pleadings, production of evidence, intervention by non-parties, to mention a few. The same goes for the rules which govern the same issues within the context of incidental proceedings, such as those on preliminary objections or the request for provisional measures, or to special proceedings, such as the request for prompt release under Article 292 of UNCLOS. I believe that it would be wrong to assume that the body of procedural law I've just referred to would be made up only of specific and detailed rules, possibly of a written nature, as contained in constituent instruments and rules of procedure. Indeed, as already alluded, 2 general and written principles are representative by way of example of procedural law applicable to the administration of proceedings, namely, the inherent powers principle and the equality of arms. Curiously, but inevitably, also due to their unwritten nature, they do not provide as such any specific regulation, at least not expressly. That is why we talk about inherent powers. It is nonetheless fair to say that they have inspired a fairly homogeneous, or common if you wish, procedural practice amongst various international courts and tribunals on strictly procedural issues. Beyond procedural law proper, one finds, as I see it, the rules and principles which govern the core of the adjudicative deliberation making by international adjudicators. Such tenets, which are meant to inform the output of the adjudicative function, can be anticipated by their abridged Latin formula, unfortunately. Jura novit curia, ne ultra petita, ne infra petita. In the interest of time, I may concisely refer to them as follows. First, jura novit curia refers to the power and duty of the adjudicator to apply the applicable law to a dispute submitted to it, where appropriate, irrespective of the arguments advanced by the parties. Second, ne ultra petita expresses the duty of adjudicators not to address claims which have not been advanced by the parties. Third, ne infra petita, on the contrary, refers to the duty not to fail to address all the claims which have been put forward by the parties, to the extent that such claims fall within the jurisdictional competence of the adjudicator. On the face of it, especially under the exceptional circumstance of a poor performance by counsel for both parties, ne infra petita may boost jura novit curia, while ne ultra petita constrains the adjudicative discretion within the confines of the claims of the parties. My second classification pertains to the three litigation context, where I argue that the just mentioned adjudicative principles apply through a differentiated series of potential and actual combinations. First, interstate and investor-state litigation. Second, human rights litigation. Lastly, international criminal litigation. The three adjudicative principles which I mentioned in Latin a minute ago apply to all phases of proceedings. However, in the interest of time, I will focus primarily on the assessment of jurisdiction, as it may impact decisively on the merits by determining the legal characterization of the disputed facts, thus curtailing the actual scope of the dispute. It is a generally recognized principle that the court or tribunal has the power to assess its jurisdictional competence over the dispute submitted to it. Such power coincides with the duty. That is obviously the case when the jurisdiction or admissibility of the principal claim is disputed by a party, usually the respondent. But the same duty applies when none of the parties raises a jurisdictional defense. That is usually, but not exclusively, the case when the respondent does not appear. There, as we say in lawyerly Latin, the judge or arbitrator will have to act ex officio or sua sponte. The interlinkage between the jurisdictional and the merits phases lies not only in the fact that often jurisdictional issues cannot be settled separately from those of the merits. It also lies in the fact that the court or tribunal, by curtailing the boundaries of the dispute on the basis of the autonomous interpretation of its mandate, determines the confines within which it is going to apply the applicable law to the merits of the dispute. These may involve an element of jura novit curia, whereby, as already indicated, the adjudicator knows and applies the applicable law irrespective of what the parties say. But such principle is to be applied in a calibrated combination with the ne ultra and ne infra petita principles. And the key question is whether such a discretionary prerogative involves the power to legally recharacterize the dispute as portrayed by the parties. Here is where a differentiated answer emerges from each of the three adjudicative contexts under consideration. And I will now turn to interstate and investor-state adjudication. As a matter of precision here, my comments are confined to traditional bilateral litigation. I mean, where the breaches invoked affect unilateral interests protected by international rules governing synalagmatic, reciprocal, if you wish, legal relationship. Different considerations akin to those regarding human rights adjudication, as we shall see in a minute, would apply to the increasing interstate litigation which bears on international rules which protect collective interest through erga omnes obligations. In the second asylum case judgment of 1950 between Colombia and Peru, the ICJ observed that, quote, "It is the duty of the court not only to reply to the questions as stated in the final submissions of the parties, but also to abstain from deciding points not included in those submissions," unquote. This statement exemplifies in most clear terms, as I said, the infra, but also the ultra petita principles which govern the jurisdictional powers of interstate adjudicators. They reflect in principle, at least, the consensual nature of interstate litigation and the autonomy of the parties in commanding the jurisdictional powers of the adjudicator. And I mean in principle. Such controlling authority precisely flows from the parties' claims being an integral part of the mandate, next to the consensual nature of both jurisdictional competence and the applicable law. The just quoted passage was recalled in so many words 50 years later by the same ICJ in the arrest warrant case in 2000. Most interestingly, though, here the court felt the need to add the observation whereby, quote, "While the court is thus not entitled to decide upon questions not asked of it, the ne ultra petita rule nonetheless cannot preclude the court from addressing certain legal points in its reasoning," unquote. The court clearly referred to points not argued by the parties. That is to say that the court would be free to rely on its own legal arguments and constructions of the applicable law, irrespective of the pleadings of the parties, but it could not address in its ratio decidendi causes of action other than those grounding the claims of the parties. This indicates by implication that the interstate adjudicator may not recharacterize the dispute as it has been curtailed and portrayed by the claims of the parties. This restrictive approach to judicial autonomy, as somewhat subservient to the autonomy of the parties, is articulated by the arbitral tribunal in the boundary dispute between Argentina and Chile. The other tribunal observed that, quote, "The competence of international judges is limited by the functions assigned to them by the parties in the case. Their powers are also limited by the extreme claims which the parties put forward in the hearings," unquote. In MV Luisa, between St. Vincent and the Grenadines versus Spain, the Eatlers firmly observed, and I quote, "The dispute brought before the tribunal by an application cannot be transformed into another dispute which is different in character," unquote. In fact, the tribunal was addressing the power of the parties in the course of proceedings according to the well-established principle ne mutatio libelli. That is to say, the inadmissibility of new arguments during proceedings if such new arguments would recharacterize the dispute as determined in the application. However, the point is made in such clear terms as to apply also to the tribunal's judicial powers in line with ne ultra and infra petita principles. At the same time, the latter principle and their considerations may be curbed or adjusted by jura novit curia. That is to say that the adjudicator would have the independent power and the duty to ascertain or curtail the scope of the dispute, obviously within the boundaries of its jurisdictional competence, which flows from the parties' mandate. And it is within such strict limitations that one should read the restatement by the ICJ in the immunities and criminal proceedings case between Equatorial Guinea and France in 2018 of the principle whereby, quote, it is for the court itself to determine on an objective basis the subject matter of the dispute between the parties by isolating the real issue in the case and identifying the object of the claim, unquote. The court went on specifying that for that purpose, quote, it examines the application as well as the written and oral pleadings of the parties while giving particular attention to the formulation of the dispute chosen by the applicant, unquote. That is to say that the time limit or phase limit, or both, for the adjudicator to characterize the dispute goes beyond the filing of the application and its contents and goes into the proceedings on the merits, but provided the court does not rely on rules and rights and duties thereto other than those invoked by the parties. Investor state arbitration case law corroborates very much this restrictive approach to adjudicative autonomy, especially for the purposes of the characterization of the dispute. In the interest of time, I will confine myself to the very first ICSID annulment decision, which, at least for our particular purposes, has been corroborated all along by investor state case law. I'm referring to the 1985 Klöckner versus Cameron first decision. The committee observed, quote, it matters little in principle that the tribunal's legal construction was different from that of one or the other of the parties, unquote. However, it qualified its statement by adding, quote, so long as the right of each to be heard was respected, and so long as it remains within the legal framework provided by the parties, unquote. And by legal framework provided by the parties, I see their characterization of the dispute. In the realm of human rights litigation, we are confronted with a rather different conceptual framework, that is one affording an incommensurably more extensive power or judicial autonomy, if you wish. And this is a power or autonomy which may be exercised at the preliminary phase, usually on admissibility, but also in a more advanced stage of the proceedings on the merits. The point is well illustrated in its general terms by the European Court for Human Rights back in the 1970s in Foti versus Italy. Quote, in the performance of their tasks, the convention institutions, then commission and court, are notably free to attribute to the facts of the case a characterization in law different from that given by the applicant, or if need be, to view the facts in a different manner, I quote. The court also addressed the time and procedural phase framework for the exercise of its power of recharacterization of the factual background. Quote, it has to take account not only of the original application, but also of the additional documents intended to complete the latter by eliminating initial omissions, unquote. According to this reasoning, the dividing line between the jurisdictional and the merits phases becomes all the more blurred. And this point was corroborated by the same court in Koenig versus Germany. Most importantly, the point was made in conjunction with the definition of the scope of jura, novit, curia in such extensive terms that go way beyond those which are recognized to apply to interstate and investor state adjudicative context. Quote, once a case is duly referred to it, the court may take cognizance of every question of law arising in the course of the proceedings and concerning facts submitted to its examination by contracting state or by the commission. Master of the characterization to be given in law to the facts, the court is empowered to examine them if it deems it necessary and, if need be, ex officio, in the light of the convention as a whole, unquote. The full statement of the court's independent power to legally characterize disputes submitted to it was later further elaborated by the court and regularly reiterated to this day. Building on the landmark Power and Rayner versus UK, the general statement in question goes as follows, quote, since the court is master of the characterization to be given in law to the facts of the case, it does not consider itself bound by the characterization given by an applicant, a government, or the commission, unquote. And the court illustrates the legal basis and the scope of its judicial autonomy as follows, quote, by virtue of the jura novit curia principle, it has considered of its own motion complaints under articles or paragraphs not relied on by those appearing before it, and even under a provision in respect of which the Commission had declared a complaint to be inadmissible, while declaring it admissible under a different one, unquote. I shall now turn to international criminal adjudication. Leaving aside the Nuremberg and Tokyo precursors, we can rely on the statutes, rules of procedure, and case law of the ad hoc tribunals established by United Nations Security Council in the 1990s and on the ICC, of course. As illustrated by the late Judge Antonio Cassese's separate and dissenting opinion in Adamovich in 1997, at the beginning, there was a significant degree of disorientation within the tribunal about the application of principles of adjudication which flow from domestic law notions. And we are dealing with principles that flow from domestic law notions. This resonates with the initial uncertainties over the power of the international criminal judge with respect to the legal characterization of the facts provided by the prosecutor in the formulation of the charges. The basic reason for this disorientation can be found in the caution deriving from the fair trial guarantees which afford the accused the right to know in a timely fashion the charges from which to defend himself. The judgment of the ICTY trial chamber in Kupreskic in 2000 illustrates the point extremely well. There, the chamber first expresses its uncertainties, it then explains its concerns, and eventually finds a solution which accommodates such concerns. In particular, it conveyed its sense of impertinence about the power of an international criminal judge to legally characterize the facts submitted to it, against the curious fact that neither the ICTY statute nor its rules established how the charges must be brought by the prosecutor. First, it found that, quote, at least for the time being, it is questionable that the jura novit curia principle fully applies in international criminal proceedings, unquote. It then illustrates the horns of its dilemma, namely, the need to preserve the right of defense of the accused together with the requirement of objective administration of justice. On the one hand, the chamber considered that the accused would not be able to defend himself with regard to a well-defined charge if, because of evidence emerged in the course of the trial, it, the chamber, decided on crimes other than those contained in the charges formulated by the prosecutor. On the other hand, the chamber expressed its awareness of the possibility for the prosecution to incur errors concerning the formulation of charges. Leaving such erroneous charges untouched would obviously amount to a serious impairment of the right of defense. Based on these considerations, the chamber came down the following balancing formula. First, allowing the prosecutor to amend its charges if in the course of the trial he or she realizes that evidence is not sufficient to prove a given charge, or if the commission of crimes not charged emerge from proven facts. Second, in case the prosecutor were not to avail himself or herself of this possibility, the trial chamber found to be itself vested with such a recharacterization power. Third, by providing under either of the two just mentioned circumstances that the accused be informed promptly and in detail of new charges, thus being allowed to defend himself. As recalled by the extraordinary chambers in the courts of Cambodia in 2016 decision, quote, the Kupreski chamber criticized the application of the novit curia principle only when it had the effect of depriving the defense of the opportunity to make submissions on a different or more serious legal characterization of the crimes originally charged by the prosecutor. Unquote. Subject to the procedural caveating point, the jura novit curia principle was plainly applied by the extraordinary chambers and very much in extensive terms. Within the ICC context, the freedom of the criminal judge to legally characterize the facts, irrespective of the arguments advanced by the prosecutor and defendant, has been firmly upheld as a requirement for the proper administration of criminal justice. A decision adopted in 2014 by the pre-trial Chamber 1 in dealing with the situation in the Republic of Côte d'Ivoire is particularly illustrative of the pointed issue. It was asked to decide over a request of declaration of inadmissibility of the ADCC amended document containing the charges. Based on the statute, the rules and the regulations of the court, the chamber observed, quote, while the prosecutor may indeed provide submissions as to the proposed interpretation of the applicable law for the purposes of the confirmation proceedings, any such submission does not constitute part of the charges of which the suspect is entitled to be informed in full. This is also consistent with the fundamental principle of jura novit curia, which places the responsibility to interpret the applicable law on the judges rather than the parties. End of quotation. Well, I shall now turn to my concluding remarks. And I would like to approach my conclusions by reverting to the asylum case quoted at the beginning of my chat. There, the ICJ provided a clear indication that the interstate judge or arbitrator should not apply the applicable law to the dispute by addressing legal issues that do not fall within the claims of the parties, however pertinent they may be to the actual and factual background of the case. In so doing, ne ultra petita gives effect to the autonomy of the parties based on their claims as an integral part of the mandate, and the operation of jura novit curia is reduced to the minimum, or should be reduced to the minimum. In human rights adjudication, the case law shows the reverse is true. Here, jura novit curia operates at its utmost, thus reducing the functioning of ne ultra petita to less than the minimum. This allows human rights courts to legally characterize the facts submitted to it without constraints other than the application of the relevant human rights convention as a whole. As to international criminal adjudication, we have seen jura novit curia operating to the extent of entitling the criminal judge to reformulate the charges presented by the prosecutor. Here again, by reducing ne ultra petita almost to nil. However, such judicial power is strictly subject to providing prompt and detailed information to the defendant of new or reformulated charges, thus affording the accused the right to defend himself from such charges. As I see it, the rationale for such a three-tier differentiated operation of the principles of international adjudication in question flows from the different nature of the judicial mandate in each of the three adjudicative contexts. That is, three different rationales of the international adjudicative function. First, in interstate and investor-state litigation, the highly consensual nature of the mandate renders the application, declaration, and elucidation of the law subservient to the dispute decision function. Second, in human rights litigation, it is exactly the other way around. There, the primary function of the mandate is to ensure compliance with the relevant conventional instrument and ensure its consistent application with regard to similar factual situations. And this is very much like domestic Supreme Courts acting as the guardians of their constitutions. Here, the dispute settlement function is subservient to the application and elucidation of the law. This is epitomized by the extreme circumstance that a human rights case may be allowed to continue even after the applicant has passed away and no heir is available. This is what actually happened in the Karner versus Austria case in 2003. Third, international criminal adjudication. The sharp difference is of immediate evidence between deciding an interstate and investor-state civil law kind of dispute, or declaring human rights violations affording a remedy to the victims on the other, and assessing individual criminal responsibility. The application of international criminal law is firmly governed by the principle of legality, which is expressed by the maxim nullum crimen sine lege. For the purposes of our discussion, this can work both ways. On the one hand, it constrains the adjudicative function as to the interpretation and application of the law. To this end, I may recall Article 22, paragraph 2 of the ICC statute, whereby, quote, the definition of a crime shall be strictly construed and shall not be extended by analogy, unquote. On the other hand, the same principle of legality requires the formulation of charges based on clear, reasoned, and consistent interpretation and application of the law to the proven facts, irrespective of what the prosecutor and defendant state, if necessary. It also requires the highest standard of compliance with procedural fair trial guarantees. Such guarantees include full, detailed, and timely information of the charges when formulated or reformulated prior to the judgment. The fulfillment of such guarantees constitutes a precondition for the exercise of the fundamental right of defense. And this brings me to my last concluding remark, namely that despite the differences just described, the one red thread which runs through each and all of the three adjudicative clusters in a unifying fashion is the procedural right of the parties to be heard. Whatever the calibration of the adjudicative tenets in each such cluster, no rules or principles providing for rights and obligations beyond those originally advanced by the parties should inform adjudicative reasoning of a ratio decidendi nature unless the parties are given the opportunity to comment on them. And this point ties in with the generally felt need for an ever more proactive attitude by international courts and tribunals in their engagement with the parties during proceedings. In fact, this accounts for the salutary increasing practice of questions coming from the bench, orally or in writing during the hearings, or in the form of post-hearing briefs. But this would be a topic for another lecture. I thank you very much for your attention.
Thank you, Professor Attilatanzi, for that really wonderful lecture. And now if we could have Dr. Nola Ferraro, if you would like to make your comment. And I understand that you would need to excuse yourself immediately after your intervention for your very important work at the ILC at the moment. So please, you have the floor.
Thank you. Thank you so much. And I have to say, this is also very important. I'm truly honored for the invitation by Doctors Wong and Jones to be a commentator for Professor Attila Tanzi. And even though it comes during the meeting of the International Law Commission, it was an invitation I could not refuse. Professor Tanzi is an international scholar and lawyer for whom I have great admiration. And I also commend you for establishing this successful series, and I agree with Professor Tanzi, it has become a classic already. So today in my comment to Professor Tanzi's absolutely brilliant discourse, I will attempt to complement his trilogy with a fourth area, the law of the sea, and focus on two issues. First, the adjudicative process and how the courts and tribunals have carved out a wide margin of judicial autonomy in the field of maritime delimitation and the applications for jura, novit, curia, and no ultra and no infra petita principles. Second, within the context of procedural rules and the competence principle, I will examine the recent cases where the tribunals have failed to apply the opt-out provisions under Article 298 of the Law of the Sea Convention, which has direct implications for the notion of the consent of states versus competence of courts and tribunals. So I begin by taking us back in time to the landmark 1969 North Sea continental shelf cases that cast the die for the court to act with broad judicial autonomy, especially through the device of equitable principles. The parties in that case had requested the court only to identify the international rules and principles for the delimitation of the continental shelves between the then West Germany, Denmark, and the Netherlands. And this was a time when the 1958 Continental Shelf Convention was in force, and both the Netherlands and Denmark were parties, but Germany was only a signatory. Now, Article 6 of the convention provided for a specific methodology, and that is of equidistance in special circumstances. Denmark and Netherlands, as parties, requested application of Article 6, arguing that it reflected or had become a rule of customary international law. Germany, on its part, wanted application of the just and equitable share, which it defined as an amount that would be proportionate to their respective coastlines. The ICJ rejected both proposals and went its own way. The court formulated a standard that would influence maritime delimitation cases for many years to come, and that is that delimitation is to be effected by agreement in accordance with equitable principles and taking account of all the relevant circumstances. The combination of equitable principles in all relevant circumstances allowed the court to sidestep what the parties had requested. The court, however, went on to make very clear that in applying the rule of equity, it was not, quote, it was not acting, quote, ex aequo bono, end quote. It explained that the rule of equitable principles rested on a broader basis, stating that, quote, whatever the legal reasoning of a court of justice, its decisions must by definition be just and therefore in that sense equitable. Judge Koreski, who was of the view that Article 6 should have applied, at least as general principles and rules of international law, in his dissenting opinion, voices concerns that introducing so vague a notion as equity into the jurisprudence of the International Court, it had opened the door to arbitrary evaluations, and he was not alone in this view. Indeed, the adoption of methodology that was grounded in the abstract notion of equity and undefined equitable principles, coupled with the very open-ended relevant circumstances with no clear source other than the broad notions of justice, paved the path really for judicial lawmaking. Now, this seems to be a prime example of the court exercising, as Professor Tanzi describes, jura novit curia, that is the power and duty of the adjudicator to apply law to a dispute submitted to it, if necessary, irrespective of the arguments advanced by the parties. The focus on equity articulated by the court in the North Sea continental shelf cases was later reflected in the Law of the Sea Conventions in Articles 83, paragraph 1, and Article 74, paragraph 1, with some modification. In that case, delimitation shall be effected by agreement on basis of international law, referring to Article 38 of the ICJ statute, in order to achieve an equitable solution. This concept of equitable result was criticized, including by Jennings, who said that this could lead to pure judicial discretion and a decision upon nothing more than the court's subjective appreciation of what appears to be a fair compromise of the claims of either side. Despite such criticism, can one nonetheless speak of a common law for maritime boundary delimitation? The rejection of the equidistant special circumstance method as a customary rule of international law was restated in many cases that followed, also applying the method articulated by the landmark North Sea continental shelf cases. And there's a whole list, but in the interest of time, I will not cite them all. Now here I refer to Professor Tanzi in quoting that from Yuval Shani, that the international adjudication has developed through a process of replication and adaptation. Maritime boundary delimitation is an example par excellence of this. And ironically, exactly 40 years after the 1969 North Sea continental shelf cases rejected the rule of equidistance in special circumstances, in 2009, the International Court of Justice in the Black Sea, Ukraine versus Romania delimitation case seems to have breathed new life into it. And the court in this case articulated, which many of you may already know, the now very well known three-step methodology for maritime delimitation. And I won't go into details, but the question is this now a new common law of maritime delimitation? This three-step methodology, which basically starts with drawing a provisional median line from the relevant coasts, adjusting it based on relevant circumstances, and then using the test of proportionality to test the equitable result, has now been adopted by cases that have followed it. And again, in the interest of time, I will not cite all of these. So another prime example of the court's exercise of judicial autonomy and acting independently is the role it played in constructing and then deconstructing the natural prolongation concept for the continental shelf. Despite not featuring at all in the 1958 Continental Shelf Convention, the court invoked the concept of natural prolongation in the 1969 North Sea Continental Shelf cases, at the time relying on the 1945 Truman Proclamation. Ironically, after the natural prolongation approach was codified in Article 76, Paragraph 1 of the Law of the Sea Convention, the courts and tribunals effectively did away with it. In the 1982 Tunisia-Libya case, even though both the parties agreed with the concept of natural prolongation, the court did not apply it, this time citing practical reasons. This was a situation where geologically there was only one single continental shelf, rendering application of natural prolongation impractical. The 1985 Libya and Malta case basically was the finale by the court for the natural prolongation principle, replacing it with the distance criteria, which is not a criteria under the Law of the Sea Convention for the in this case. So even though the 1982 Law of the Sea Convention was not enforced and the court was not asked to delimit any exclusive economic zone, the court found that the very existence of the EEZ in the convention to be a relevant circumstance that it could take into account. Now I want to go on to the next set of issues, and that has to do with Article 298, the optional exceptions clause in light of the competence, and implications for the notion of the consent of states. There have been recent cases where the jurisdiction of the tribunal has been challenged, invoking the military exceptions provision of Article 298 to the compulsory dispute settlement under Part 15. Now, of course, there are other cases that have asserted this option for other grounds, but I cannot go through all of them in the limited time we have. Let's go to the question of competence in relation to the consensual nature of international adjudication and the autonomy of states. The consent of states to judicial processes, international judicial processes, is a fundamental rule of international law. Part 15 of the Law of the Sea Convention imposes compulsory dispute settlement for parties upon ratified, but it also provides for optional exceptions, which allow parties to opt out of compulsory adjudication in specific cases, such as disputes over maritime boundaries, military activities, law enforcement, historic rights, and entitlement. So in the 2016 South China Sea arbitration case, which raised several preliminary jurisdictional issues concerning whether the arbitral tribunal had jurisdiction, was precluded by China's having opted out of several invoking Article 298, which included maritime boundary disputes, historic titles and rights, and military activities and law enforcement. Now, China did not appear at any of the proceedings, but indirectly, through publication of position paper, made a general statement that the dispute was excluded under Article 298 of the Law of the Sea Convention. The Annex 7 Tribunal examined the matter in propria motu. In the preliminary phase of determining the limitations and exceptions to its jurisdiction, the tribunal found it had jurisdiction on the basis that the questions were not, or quote, not exclusively preliminary nature. The tribunal also found that the question of whether the activities fell under the military activities or law enforcement were also part of the merits phase. This is an example of the blurring of the procedural law stricto sensu and the merits phase as described by Professor Tansey. The tribunal maintained jurisdiction, notwithstanding the expression of China against consent in certain cases being submitted to international adjudication as provided for under the Law of the Sea Convention. Additionally, in the merits phase, the tribunal stated, quote, "The tribunal will not deem activities to be military in nature when China itself has consistently and officially resisted such classification and affirmed the opposite at the highest level." And this I will come back to later. In the next case is the case concerning the detention of 3 Ukrainian naval vessels brought by Ukraine against the Russian Federation. This was for provisional measures before the International Tribunal for the Law of the Sea. And Ukraine sought release of its Navy vessels that had been arrested by Russian Coast Guard after the use of force for the alleged unlawful entry into the Kerch Strait. Of course, as you know, the underlying context is a dispute over sovereignty between Ukraine and Russia over Crimea, including the status of the Kerch Straits. Russia did not appear at the proceedings, but through a note verbal raised the military activities exception of Article 298 that it had made upon ratification of UNCLOS. So the title of an European Journal of International Law blog written by James Kraska is descriptive of the views of some scholars on the decision of ITLOS in this case. Quote, "Did ITLOS just kill the military activities exemption in Article 298? Indeed, the tribunal advanced a standard so broad to have virtually given a carte blanche to judicial determination of the military's activities exception under Article 298, potentially undermining the otherwise sacrosanct principle of the consensual basis of international adjudication. First, ITLOS held that the distinction between military and law enforcement activities cannot be based solely on whether naval vessels or law enforcement vessels are employed in the activities, saying that these may only be relevant factors but not determinative. Second, the tribunal found that the distinction between military and law enforcement activities second, they said that the state itself characterizing the activities in question could not be determinative. And this is in contradiction with the tribunal in the South China Sea case that I recently quoted, which relied heavily on China's own characterization of the activities not being military in nature. Instead, the standard pronounced by ITLOS and the Kerch Strait case was that the military and law enforcement activities must be based primarily on an objective evaluation of the nature of the activities in question taking into account the relevant circumstances in each case. Relevant circumstances leaves an extremely broad margin of discretion to courts and tribunals to make a case-by-case assessment whether an activity qualifies an exception to compulsory dispute settlement under Part 15 when the state party has exercised its conventional right to opt out. There was also a second arbitration case brought by Ukraine against Russia in the dispute concerning coastal states' rights before Annex 7 Arbitral Tribunal. And once again, Russia raised the military activities exception under Article 298, relying on the context of the military conflict in the Crimea dating back to 2014. In addition, Russia asserted Ukraine's claim that Russia's military vessels had used physical force to exclude it from access to hydrocarbon fields and fisheries. Again, the arbitral tribunal in this case rejected the application of the military's activities exception, stating that the military's activities exception was not triggered simply because the actions took place against the broader background of an alleged armed conflict. And again, that the mere involvement or presence of military vessels alone would not be sufficient. So in these cases, questions are raised whether in the interpretation and application of UNCLOS, the tribunal and the arbitral awards have trespassed the boundaries of an appropriate calibration between basic judicial principles that Professor Tanzi has discussed in his lecture today. So in conclusion, in this brief overview of selected cases in the law of the sea, I hope to have illustrated the tension between the autonomy of states and that of judicial powers within the procedural and adjudicative functions of international dispute settlement. The balance between the jura, novit, curia, and the ultra petita seems clearly to have fallen on the side of the former. Lastly, in the cases where parties have withdrawn their consent to compulsory jurisdiction, as provided in Article 298 of the Law of the Sea Convention, these examples have shown the preeminence given to competence, wherein the tribunals have guarded jurisdiction through their powers of interpretation, carving out broad standards of discretion for future courts and tribunals. The common law of adjudication of the law of the sea is developed through the assertion of autonomy of the courts and tribunals, countering the principle of state autonomy and consent. And I thank you very much for your patience and for listening to my comment today.
Thank you, Dr. Arl, for joining us from Geneva and for commenting on Professor Tanzi's lecture. Thank you so much for being here. And now I would open the Q&A. Professor Tanzi, we have so many exciting questions on the intervention. So perhaps if I could start with a question from Xiao Mao, who asks you, what are the remedies for violation of these rules in international courts and tribunals? Does the violation lead to invalidity or appeal of the decision? Are the remedies also different in international courts and tribunals with different functions? And Professor Tanzi, I would like to defer to your preference. Would you prefer to answer questions on an individual basis, or would you prefer me to categorize them into common themes and clusters?
I would be tempted to say as it would make your life easier, except that I have bad memory and I may forget about questions, and then I would then resort to you and ask you to repeat the questions. So perhaps I would take one question by one. Well, I would imagine that this question would arise, and this is a very appropriate question. The rules about adjudication are addressed to adjudicators, and what happens if they don't live up to such standards? You hinted at the possibility of judicial review, annulment. In international law, public international law, we do not have such procedural system. Interestingly, I wonder, the principles that I've been discussing have been applied, argued more than anywhere else within the context of annulment committees, within the framework of exit arbitration, where you don't have an appellate system, but you have an annulment system. You have grounds for annulment, traditional ones based on excess of power, lack of reasoning, and the rest of it. There is a tendency of a rather protective nature about the validity of annulments. But in traditional interstate adjudication, you do not have an appellate system, and then you would say, but then what's the purpose of these rules if they cannot be somewhat vindicated in forms of nullity, of final judgments or awards? Well, I mean, the whole system very much, I suppose, every legal system basically, first and foremost, even for subjects of the law, recipient of rules, is based on spontaneous compliance with the law. But and we know that the enforcement mechanism in international law leave much to be desired. But if that is the case with regard to material recipients, it applies all the more so to international adjudicators who, I mean, you have litigation strategy which apply policy considerations for states, for the disputing parties, but there is also a fair significant amount of policy considerations to be taken into account by an international court or tribunal that would and should make its best effort to comply with the general principles of adjudication in order to enhance its legitimacy and authority. And so far, from my ongoing research, I have the general perception that apart from, particularly when a case doesn't start on the right foot, when the defendant does not appear, that you have problems of acknowledgement, recognition of the authority of the tribunal, at least for that particular decision. Take, for example, the classical case between Nicaragua and the United States. The United States pleaded thoroughly against the jurisdiction of the tribunal of the International Court of Justice once the ICJ handed down its decision on jurisdiction in the affirmative. The United States did not appear and pulled out of, withdrew their declaration of acceptance of the jurisdiction of the ICJ. That was 1985. George Shultz was Secretary of State for the US. So it is, and I believe that despite the lack of a judicial review mechanism where you may hold a given tribunal court accountable for compliance or non-compliance with such principles, there is merit in focusing on those principles, so that the boundaries, the standards, the legal yardstick for the legitimacy of the exercise of the administration of international justice is looked at. But the point is a good one, but it's a structural, systemic question of the overall system of public international law. I hope this satisfies your curiosity in question.
Thank you, Professor Tansi, for this, for your response. The next question that I would like to pick is from Dr. Lorenzo Palestini, a lecturer at the Center in International Dispute Settlement of Geneva. And then after Dr. Palestini's question, I would like to ask you a question from Professor Federico Ortino, followed by a question by Dr. Vladislav Lanovoy. So let me first ask you Dr. Palestini's question, which is that in interstate and investor state litigation, are not the ultra and infra petita principles often taken over by the power of courts and tribunals to define and frame the subject matter of the dispute? And he refers to some examples that you had mentioned in which preeminence was given to the autonomy of the parties, but judges and arbitrators are not always so differential. And the examples that he points out are the nuclear test cases in which the ICJ arguably departed from non-infra petita by reframing the scope of the dispute as one pertaining only to cessation and not reparation.
Well, I think that is a very, very good question. First of all, it allows me to indicate that these principles apply not just to the preliminary objection phase or just jurisdictional phase, even where there are no objections to it. It applies to the merits, and it also applies to the actual assessment of reparation if the tribunal finds for the applicant and comes down to the decision that reparation is due. A separate analysis should be carried out of the application of these principles to reparation. I remember in the Corfu Channel case, experts for claimant reached a given number for compensation, and the court-appointed experts came to the conclusion that the number would be higher, but the court said, I cannot, based on the principle ultra petita, award any higher compensation than that asked by claimant. And it said that in so very many words. More interesting, though, is the point you're making. What about claimant asking for compensation, and the court, is it allowed to decide on restitution or the other way around? Interestingly, I believe the principles of adjudication that I have been addressing should be looked at in the light of the actual secondary rules on the law state responsibility. And there the draft articles, the letter of the draft articles supplemented by commentary is a bit ambiguous about priority. I mean, if you look at the letter of the relevant provisions, there is priority for restitution, and compensation comes into play when restitution is impossible. But then there is language applying for a more flexible parameter. And I believe that the commanding power of the applicant is important. But I wouldn't make a strong statement here because I am sitting as an adjudicator, and I have an idea, but I would, if you can bear with me, not going any further down this point.
Thank you, Professor Tanzi. And now for the question from Professor Federico Ortino. He thanks you for the brilliant lecture, and his question is, who determines and how the rationale of the adjudicative function for each context? Is it the contracting parties or the respective adjudicator, or is it someone else? For example, under what conditions could one put the investor state system together with the human rights litigation and argue that the system is to ensure compliance with specific good governance principles, and ensure consistency.
Right. Well, that is a very good point, and actually would bring me to, with regard, for example, to interstate adjudication to decide issues, the application of these principles in the context other than the traditional bilateral one, where definitely the adjudicative function comes down to deciding a dispute bearing on unilateral interest stemming from synalagmatic bilateral civil law-like regulating relationships, erga omnes obligations. I mean, it takes a Myanmar case currently pending before the ICJ. Well, there, as I see it, the administration of justice would very much have to take into consideration the elucidation, the consistency, the clarification and application of the law, whereby then the decision of the dispute would be very much the attention on the decision of the dispute gets very much on a par, level of importance with the clarification of the law, very much on a par with the function, adjudicative function, as I see it, which is being carried out and is carried out by human rights court for the very purposes I indicated. I mean, where do they draw their function from the mandate? Now, if we take, and in fact, I don't draw so much of a distinction between interstate traditional adjudication and interstate international arbitration, because even before a permanent adjudicative body such as the ITLUS or the International Court of Justice, the court or tribunal are vested in their function by the will of the parties, the consent of the parties in investing the ICJ or tribunal with the jurisdictional competence, defining it, curtailing it, ratione materiae, by whatever consensual instruments gives the court jurisdictional competence in any given case, and determines the boundaries of the applicable law. When you have the application of a piece of international law produced for the purposes of protection of indivisible collective interest, well, the court is to adjust its mandate, and it's there itself sort of upholding and vindicating general indivisible interests that have been raised by one state acting sort of uti universi on behalf of the international community. And there I would apply to the ICJ that sort of function that I have indicated previously, that is performed by a European or inter-American, African, whatever, court of human rights, very much by the same yardstick of a constitutional court as the guardian of the applicable law, where the settlement of the dispute becomes observant to the consistent, proper, clear application of the law.
Thank you, Professor Tanzi. And now on to the question by Dr. Vladislav Lanovoy. Do you think courts and tribunals have adequately drawn a distinction between new legal and factual arguments that may be advanced by the parties in the course of proceedings, as opposed to formulating new claims? The limit on presenting any such new legal and factual arguments is to not transform the character of the dispute brought by an application. For example, in the military and paramilitary activities case, Cameroon and Nigeria, preliminary objections. Dr. Lanovoy asks, have other courts and tribunals followed a similar approach?
That's a very good point. Well, facts and law is also the distinction or interlinkage between facts and law, and the conduct of the parties in proving the facts and arguing the law. As I see it, and I suppose this flows from my general approach, whereby I see jura, novit, curia, and discretion of the court rather restricted in terms with regard to interstate adjudication. The court is to rely on facts strictly proven by the parties. And when it comes to characterizing such facts in applying the law, particularly when it comes to the use of force, it is inevitably a degree of adjudicative discretion, whereby I do not think that we are still in the domain of the relationship between application of the law within the boundaries of jura, novit, curia as restricted, contained, constrained by petita, or by not applying the law to facts that have not been proven by the parties. I suppose that there we are outright within the realm of the actual exercise of its jurisdiction beyond these procedural constraints. And then you could criticize a court for going beyond the arguments of the parties, which is an exercise of discretion which is not necessarily governed by jura, novit, curia. Jura, novit, curia, rather technically, applies to the circumstance in which the court or tribunal is not to recharacterize the facts legally by applying rules, the rights and duties stemming from such rules that have not been invoked by the parties. Interpreting the law which has been pleaded by the parties differently from the parties, to me, falls short of the issue of jura, novit, curia and pertains to the regular, inevitably independent exercise of jurisdiction by the court. And that is to say that not every discretionary element in the decision-making process, a judicial making process, is regulated by jura, novit, curia. And the countervailing principle of petita, that is part of the core decision making, judicial decision making of a court. And then I have made this reasoning in an article which is just about to be published by JIT's Journal of International Dispute Settlement with regard to the Enrique Alexi case. I see in the legal literature significant efforts at criticizing what various courts and tribunals, whether it's right or wrong. I mean, and that is interesting, but it is to do with the way courts and tribunals interpret the law within the boundaries of their jurisdictional competence. And then you may agree with the way a given court or tribunal interprets and apply the substantive law, which is the applicable law, which has been pleaded by the parties. And obviously in its reasoning, the court or tribunal may go by the reasoning or may go against the reasoning. It's usually going a third way, but this does not mean that the court, by doing so, exercised jura novit curia powers, so long as it applied the law which has been invoked by the parties. That, in that case, that is part of the core exercise of judicial activity beyond or behind jura novit curia considerations. And there, of course, I believe, as a matter of judicial policy, the court, as much as it should try to settle the dispute, or at least to decide the dispute in the most convenient and efficient way, as it is effectively considered as such by both parties, is to try and keep within the boundaries of the rule of reason, a general acknowledgement of the appropriateness of its interpretation of an application of the law, but we are not within the realm of jura novit curia.
Thank you, Professor Tanzi. I'm also aware of time that we are in fact reaching the end of our session, but I wonder, because we have so many questions, including questions from viewers from Philippines and Brazil. Regrettably, we won't have time to go into that, but I feel that it would be nice to end with one question, if you could stay for a little bit longer, from my colleague, Dr. Antonio Coco, because his question pertains to the international criminal adjudication front of your lecture. And as you have discussed the various interstate aspects, investment aspects, human rights aspects, it would be nice to end on this note so that we can have an overall engagement with your lecture. So Dr. Coco's question, and first he thanks you for the excellent and insightful lecture. His question concerns the practice of recharacterization of facts by judges in the international criminal proceedings. Do you think this practice to be particularly problematic from the perspective of the principle of equality of arms, especially the recharacterization is due to victims' submissions or the judge's own interferences? And after all, shouldn't the prosecution bear the burden of poorly or improperly formulated charges? And if the practice is deemed to be acceptable, what measures would you think are appropriate to redress the imbalance towards the defense?
Well, thank you very much. I believe I see in the rationale, the spirit of this question, very much the concern that I had in interpreting the concerns by criminal judges. And I indicated the initial disorientation of the ICTY, which has later developed into a more confident, self-confident attitude, where precisely the issue was that of fulfilling compliance with the right to defense and knowing the charges and not condemning any accused based on charges that have been reformulated in the course of proceedings. And there is where I see, particularly in criminal justice, the utmost importance of the procedural law. I have distinguished the law of adjudication from procedural law. This is where you have a full merger between principles of adjudication with the principles of procedural law. And there, of course, the equality of arms plays a fundamental role when it is the public prosecutor who reformulates the charges in the course of proceedings. By the time new evidence pops up during the trial, and then as I have quoted before, in case of such reformulation, which is being allowed, also on the part of the prosecutor, but then the equality of arms, prosecutor, defendant, is to be ensured by giving the respondent with the utmost rigor the right to and the time, the quality, the detailed nature of the reformulation, the opportunity to defend themselves. And if I may seize my last minute, I may complement my answer to Professor Ottino. Indeed, the mandate for the adjudicator is to be drawn on a case-by-case consent of the parties to the jurisdictional scope to be within which is the given adjudicator is to act. And if you take, even in interstate adjudication, the difference between traditional adjudication in bilateral legal context and you shift onto vindication of erga omnes obligations, the mandate stems from the mandate that stems from, for example, the Genocide Convention. There is a collective mandate which changes completely the rationale of the adjudicative function. Is no longer a bilateral dispute settlement function, but there the court is acting as the guardian of the parties to the convention, which reflects a customary piece of law of a jus cogens nature, and there the court is definitely sitting as the judicial guardian of the international community. And you see a clear shift, a qualitative shift in mandate. But originally, it all stems from the consent of the parties, because the parties to the convention gave in its Article 9 on jurisdiction that kind of function to the International Court of Justice. I hope this satisfies, and I'm sorry for not having satisfied all questions that have not been delivered, and if I've not satisfied all the nuances of the questions that have been put to me.
Thank you, Professor Tanzi, for the excellent responses to all the very excellent questions, and of course for your lecture today. Thank you for being our speaker. Thank you for joining us. And to the audience, thank you for zooming in and joining us for our lecture today. I wish you a good day, evening, afternoon ahead, wherever you're zooming in from. Bye.
Thank you. Thank you very much.